The prosecution has declared that Vybz Kartel and his co-accused must be allowed to clear their names. The prosecution further stated that it wants the murder case to be retried on its merits and not to be determined on technicalities. The public interest in the final determination of this criminal trial requires that such charge should not be left untried, or rather for the matter to be determined on its merits. Adidja Palmer, Sean Campbell, Kyra Jones, and Andre St. John were convicted of the murder of Clive Williams, which occurred in 2011. The Privy Council, however, who remains silent on the merits of the evidence, throughout their conviction on the grounds of jury misconduct in March. In continuing her submission before the judges, who will determine whether the case is to be retried, Tugwell, while asserting that the prosecution cares about the constitutional rights of the accused men, acknowledged that the men's right to trial in a reasonable time has been breached. She argued that there are appropriate remedies in place to satisfy the breach, in that there can be a public declaration and acknowledgement of the violation, and an order for the expedition of the matter. Given the length of time that the men have spent in custody, Tugwell said bail may be considered, noting that there are case law to support this position. She said bail, if granted, would also allow Palmer to get treatment and to undergo surgery for Graves' disease, thereby preserving his life to stand trial. In light of Palmer's medical condition, the Crown Counsel said consideration could also be given for him to be granted bail. At the same time, Tugwell, in answering a question from Justice MacDonald about whether keeping the accused in prison was not inhumane and oppressive, said Palmer, despite his medical condition, which includes a failing heart, is not without hope, as surgery is recommended to improve his condition. She further added that if the court were to decide solely based on failing health against ordering a retrial, it would set a bad precedent. MacDonald Bishop reminded Tugwell that the court has maintained that all factors will have to be assessed in arriving at a decision. She also asked for it not to be said that the court would sit and decide the case based on Mr. Palmer's health alone. Tugwell further apologized while indicating that the health issues must not be given excessive weight. As she continued with her submission, Tugwell said a total acquittal or dismissal of the matter due to the delay should be the very last resort and only be reserved in extremely exceptional circumstances where it has been established that it is impossible for the appellants to have a fair hearing. Furthermore, she said, despite the breach, there is nothing to suggest that a fair trial is impossible. In fact, the contrary has been established. Meanwhile, earlier in the trial, the assistant to DPP, Janet Forbes, proposed that bail could be offered to Palmer to address the medical situation and his weakened mental state. On the other hand, Forbes noted that if bail is not granted, the Department of Correctional Services has provisions that could also address Kartel's mental state. Forbes, during his submission, also reiterated the prosecution's argument that the safeguards available are sufficient to mitigate any risk that the pretrial publicity may cause. He further emphasized that despite the heightened publicity on the matter, it is still possible for the men to get a fair trial. He said that there may be a miscreant jury. Generally, it is to be assumed that the jury will abide by the oaths or affirmations. He, however, asked the court to bear in mind the observation made by case law that the risk that members of the jury may be affected by prejudice cannot be wholly eliminated. Any member may bring personal prejudices to the jury room, and equally, there will be a risk that a juror may disregard the direction of a judge when they consider that it is contrary to what justice requires. Justice MacDonald Bishop disclosed that it had received confirmation from the Supreme Court that since 2018 only 2 matters were sent from the Court of Appeal to the Supreme Court for retrial. The two matters were sent back for retrial in 2022 and 2023, but no trial dates have been fixed. In the meantime, the hearing, which is also being presided over by Justices David Fraser and Williams, is said to be concluded on Tuesday.